about an intentional inheritance, about us all really being intentional about what we're doing. And when I tell you how I define inheritance, it might be a little bit different than what you think about, but I'm sure it's all part of the same thing, but slightly different. So I want, as we go through this today, I want you guys to keep that word intention in your mind, and we'll talk about what I think that means. Okay, this is just a little bit about who I am. Jim mentioned I have been a licensed attorney for 33 years. Started when I was 7. He thinks I'm 40, 60. But anyway, so 33 years. I retired from practicing law actually in 2017, and I just consult now. It's the same information. You just can't sue me for malpractice, just so you know, and I don't have to pay my malpractice premiums. I have been a real estate investor for 21 years. I think it's going on 22. Private lender for 20 years, a national speaker for 30 years. I did found the AIM Higher Academy. AIM stands for Alternative Investing Movement. That's just it's like Inner Circle. It's just a monthly membership where we talk about various issues. And then as of last year, as you heard, Wendy Sweet and I are the co-founders of the Sweetheart Women in Real Estate Mastermind. You guys are going to hear more about that at the end of the presentation. Anyway, all right, so before we get started, I want you guys to, you don't have to close your eyes, but I want you to think in your head, what is your most important thing? What's the most important thing to you? What got you here this week? What is your why? Why are you here doing this? Why are you working so hard to create wealth? Take about 2 seconds. You guys probably all had something immediately jump into your mind, right? Everybody ready? Anybody not thought about that yet? I think, okay, it's quick, it's easy. So I don't think this is going to apply to any of you, what I'm about to say, but is it money? Was it money that's your most important thing? Doubtful. Was it travel? Now, I love to travel, and that's part of why I like to make money, but it's certainly not my most important thing or my why. Is it fun? I love a good time. It's very fun. Is it your friends? I love hanging out with friends, and that's one of the things I love about the Mastermind. We had a great time last year. Is it accolades? I don't think anybody's in this room to get awards, get recognized, be a high achiever so everybody else bows down to you and thinks you're great. Not one single person is in here for that reason. Or is it your family, your loved ones, your friends, your church, your charities, what I'm calling collectively your loved ones? My guess is that pretty much everybody in this room thought about their family, their loved ones, the causes that were important to them. And that is really why you're here. Why do we all work so hard every day to create a future for ourselves? It's not just for our mortal life, right? It's for the people we leave behind, whether that's our family or whether that's our charitable causes. So as we go through talking about inheritance, I want you guys to remember that if you're one of the people, most of you probably are, who said the most important thing to you is your family or your loved ones, your charities, keep that in mind as we go through these slides. And I'm going to encourage all of you to put your money and your time where your mouth is on that, or where your thoughts are on that. Okay, intention matters. So let me tell you a little bit about my background as an estate planner. I knew I wanted to go to graduate school. I started law school when I was 25. I had no idea what I wanted to do with my life. I just knew I wanted a graduate school education. My parents had gotten divorced when I was young, and my dad had run off with my mother's best friend, and my mom she had given up her career to marry my father right out of college. And so all I heard growing up was, you have to get your graduate degree so nobody can ever do that to you, right? So I grew up thinking, college isn't it? I got to get a graduate degree. Now, I don't always feel that way now, knowing what I know as a grown-up, but I didn't know what I wanted to be when I grew up, and I thought, well, I'll go to law school. If nothing else, they'll teach me how to learn. They'll teach me how to think. So I started law school having no idea. I didn't want to go stand in front of a judge. I didn't want to do any of that, partly because I think if I were a prosecutor in the criminal, I'd be worried I'd be prosecuting innocent people. And if I were a defense attorney, I'd be worried I'd be putting bad people back on the streets. I didn't want to be a corporate lawyer, all that kind of stuff in the courtroom. So I go to law school. We have the first semester with just a bunch of classes, general classes. And then second semester, I took my first wealth transmission course. I was like, what the heck is that? Well, it's estate planning. It was an estate planning course. And I was mesmerized from the first moment that professor opened his mouth. I thought, oh my gosh, this is what I want to do. So after I got out of law school, that's what I became, an estate planning attorney. I practiced in Alaska for many years as an estate planning attorney. And as time went on, of course, you represent high net worth people. They bring in their real estate issues or their business issues or their elder law issues. So I started doing all of that all dovetails really well together. But I've been doing estate planning for 33 years. Graduated in 1991 from law school. And I have probably planned, and this is no exaggeration, over 5,000 estates, maybe 10,000 in 30-some years. I've administered hundreds and hundreds and hundreds of estates when people died and passed away. And there's one thing I can tell you. Those families that were intentional about their estate plan and got everything in place and informed their family about what was going to happen if they died or became disabled, those families suffered far less than the families who did not plan, whose parents, for instance, did not plan, or whose spouses did not plan. I have seen incredible horror stories. I have seen families torn apart forever by problems with failure to plan. I have seen families bonded forever when things were put together nicely. I can't stand up here, we don't have time to tell you all the stories, but I am so passionate about this subject because I've seen it all. And I mean, it's giving me chill bumps right now when I think about it, because it is, and you'll see when I say this later, to get this stuff in order for your loved ones is the nicest gift you can give your loved ones ever. It's nicer than money. The only other thing nicer might be your time. But it's the nicest thing. It's what I call your ultimate love letter. I've been calling it that for 15 years probably, and you'll hear more about that too. But be intentional with what you're doing. All right. I think of inheritance not just at death. I think of it as 3 phases that we have to plan for. One is during your life. Most people don't think about inheritance in connection with while you're living. The second time is if you're alive but you're disabled to the point where you cannot make your own decisions or take care of yourself, right? And the third point, which we all think about, is after death. So we're going to talk about all 3 of these phases. The during life part, I think, is more the inspirational part, and I probably really don't need to talk to any of you about this, but I'm going to preach it anyway, just in case we all get busy and forget about the things that I know are important to you if you sat down and thought about it. By the way, I'm new to Canva, so I'm having fun with all these little cartoony looking things, you know. Oops, how do I go backwards? There we go. It's very fun, like life. I was like, oh, that's so cute. I got to throw that in there somewhere. All right, I am not creative. I'm your left brain lawyer, people. Left brain. For me to get on Canva and find like, ooh, I can actually drag a picture over there and make this cute little cartoon, it's very exciting to me. I don't know what to tell you. 60 years old, I've discovered something new and exciting. Okay, so I think, and those of you who are here and heard me talk about legacy know how I feel about this. I think your inheritance, your legacy, starts well before your death. It starts during your life. And it is not just what you leave to people when you're gone, it's what you leave in people. It's the name you carve on their hearts and not on their tombs, not on your tombstone. It's very, very, very important. So see my cute little pictures? There's the trust and estate planning, and then there's the love and the family. Anyway, I have to maybe interpret these things because it meant something to me when I put that stuff up there, but maybe it doesn't mean anything to you. Okay, so leave them an inheritance of love. Well, that sounds easy. We all want to leave an inheritance of love to our family, our loved ones, our charities. We want to do that, but what does that really mean? So if we say our family is the most important to us, I'm just going to say family, but you guys know I'm talking about whatever entity or family or person is important to you or people. You know, spend quality time with them. For me, I think back to, my kids are all grown up, by the way. They're 31, 29, and 24, and I have 3 stepchildren who are all grown up. I think back to when I was divorced, starting my own law firm. I just worked all the time because I thought that would somehow, if I had my own firm, it would make me have more time for my family, which was a joke, as all we entrepreneurs know. That didn't work out that way. Anyway, I look back on it, and my biggest regret, although my children have all grown up fine, my biggest regret is I didn't spend enough time with my kids. I was doing it for my kids. I was trying to create wealth for my kids, but I wasn't there for my kids in their lives as much as I wanted to be. I thought I was, but in hindsight, I wasn't. So spend quality time with them. Give them the very, very best of you. Give them everything you've got to be the very best of you. Show them gratitude. Be grateful for them. Show them that you're grateful for other things. Teach them a culture of gratitude. I think it was Cicero who said, gratitude is not only the greatest of all virtues, it is the father of all others. And I think that's a very powerful statement. So every day when you get up, be thankful and let your children or your loved ones understand what gratitude means. Have patience. Patience not just with your kids, your grandkids, your friends. Have patience with yourself. How many of us have a nasty little voice in our head that gets mad if we mess up? I do, right? have patience with yourself. Give yourself the grace to mess up and say, I'm human. It's part of the human condition. Move on. Mirror that or model that for your loved ones so that they can have patience for themselves and others. Respect them. Respect yourself. Same thing like patience. Model that for people. And, of course, love them. And be someone who shines that light of love in the world. God-like, whatever, right? Show that to people. Don't gossip. Don't do all these things that may be fun in the moment, but you're modeling for other people whether you know it or not. And like I said, I don't really think I need to tell all this to you guys in this audience, but, I wanted to use these cute little cartoons, so I'm doing it. Okay, so share your knowledge and experience. We talked a lot about this 2 years ago in Legacy. Everybody in this room has something that they can share with others and help others grow in their life. I would just encourage you to inspire and motivate others and realize that you all have something special to share with other people. And this is an important one. We get so busy trying to buy things, whether it's consumer debt or leverage debt is okay if the properties are worth enough. But don't get so caught up in providing things for your loved ones that you leave them with a mountain of crushing debt. Because I've seen so many families struggle when someone died and there was so much debt that was really unnecessary. So try very hard not to leave them with crushing consumer debt, large credit cards. They won't necessarily be legally responsible for it, but they might feel morally responsible for it, or they might get the letters all the time, even if they're not legally responsible for it. And the last thing is just in everything you do, be a role model. Be the light you want to see in the world, obviously. Help create the world you want your loved ones to live in, even if you're not here. All right, now, that's all the life stuff. But I want you guys to visualize something with me. You can close your eyes if you want to. You don't have to. First thing I want you to visualize is your life as it stands right now. When you wake up in the morning till the time you go to bed, what do you do all day? What are the things you decide? What are the things you think about? Who are the people you have to call? What do you have to manage? Who do you take care of? What appointments do you have to go to? Think about your life as that is right now. Everything you do that you're responsible for. Now I want you to think that in a split second, you can't do any of that. You can't do any of it. You're either in a car wreck, you're dead, you got dementia that came on suddenly, you had a brain aneurysm, something has happened that everything stops. Nobody can call you for information. No bills get paid if you're the one who paid them. Nothing happens. How does that make you guys feel? Yeah, let me go back a minute. Fearful, right? Fearful. So yesterday, maybe it was Sunday, whatever day I flew in, I think it was Sunday, I'm with my friends, Chris and Patty, we're hanging out, and I just, scrolling through Facebook looking for something, and I see a friend of mine that I knew many years ago, and we haven't known each other or been around each other in a lot of years because it was part of my prior marriage friendship circle. Anyway, she posted, here's my husband's obituary. I thought it was a joke. I'm like, yeah, right. I just saw them on Facebook. He's not dead. Why would she put that up there? And then I started looking at the comments, and I'm like, oh my God, he's dead. 62, dead. I almost fell off the couch. And I actually texted my ex-husband, who went to high school with this gentleman, and I said, oh my gosh, what happened? Is this really true? And he said, yep, he had a series of strokes within the last few weeks, and it killed him. 62 years old, working full-time, healthy as far as I know. And my first thought was his poor wife and grown children. And my second thought was, oh my God, I hope he wasn't the decision maker for everything. And if he was, I hope he planned his estate. I hope his family knows what to do next. I mean, that's the fear, that's the job that makes me think that way. But anyway, I think it's very important that you guys visualize this, and I beat people up about this, even myself. I mean, I have to do this. I'm not perfect. My estate plan is not perfect. It's getting there. It's not perfect. But I want you to really think about it, because most of the people in this room are the entrepreneurs, the type A people, who are out there making the decisions, dealing with the contractors, making the offers, paying the bills, getting the insurance on the properties, doing all this stuff. Is that you? Anybody in the room that's you? There should be a lot more hands going up. For those of you who are that person, Do you have someone right by your side all day, every day that knows exactly what to do if you're not there making that decision or making that phone call? Who knows the passwords to your Airbnb app or anything else, right? Anything else. I have two business partners, Chris and Patty, here in Richmond. We have vacation rentals, and they manage them. I'm sort of the silent partner in North Carolina. And they're in there, they drive together all the time. They're flipping houses, they're doing all this stuff. They're always in the car together. And I had this thought, I don't know how to get onto our Airbnb platform for those properties. I have my own. But what if they have a car wreck and they're both gone at the same time? All that information is in their head or on their hard drive. So I called Chris up and said, please send me all the passwords and stuff, which she did. So at least we got that part done. But those are the little things you don't think about. So let's think about that, because guess what? None of us are getting out of here alive. None of us, not a single one. And more importantly, perhaps, we all know that, but nobody thinks about the fact that 1 in 4 Americans suffer some sort of disability during their lifetime. 1 in 3 between the ages of 35 and 65 suffer the type of disability that keeps them from working for at least 90 days or more. So think about what you do, and if all of a sudden tomorrow you couldn't do it for 3 months, 6 months, a year, permanently, what would that do to your business? So are you prepared? If something did happen to you, and I know which column you're going to be in, how do you want your loved ones to feel? Do you want them to feel stressed out, worried, guilty that they can't pay the bills, scared, overwhelmed? Or do you want them to just be able to grieve you and focus on that because they feel confident and supported and loved and secure because they know that everything has been taken care of and the wheels are in place, ready to go, right? Everybody wants the second column. And guess what? It's your choice to make. We all have the power to get this done for our loved ones. And if we say we don't because it takes too much time, it's too expensive, whatever, I'm going to have to call BS on that. It's no fun. It's not bad, but anyway, you can do it. And I want you to be intentional about it. And I'm preaching a little bit because it's so incredibly important. I think of an inheritance or an estate plan as more than just the documents, by the way. It's the documents that need to be the right documents for the right circumstances, but it also needs to be getting the information in an available place for your loved ones so they know how to implement the documents, right? We'll go through that a little bit more. I call that combination your ultimate love letter. Having the documents and having the information for your family. So this big notebook, they just know what to do. They might have to call a lawyer, but it'll be easy and much cheaper if they can just hand everything over to the lawyer. All right, let's get into the nuts and bolts. So we're tired of the preaching now. We'll get into the nuts and bolts. So we're going to plan for disability first. Don't you like the little Band-Aid on the brain? I thought that was really cute. My brain feels like that about every other day. I need a Band-Aid for my brain. Okay, so we talked about this already. 1 in 4 Americans will experience some form of disability. Dementia, that is often with the brain, or you're in a coma. You've been in a car wreck, you're in a coma. You can't make your own decisions. It can be fast, it can be a slow process. But at some point, you might not be able to manage your own stuff. You might be alive, so your will doesn't kick in, or your trust doesn't necessarily kick in for the death part of it. But somebody's got to make decisions for you. These are the documents that I think you should have to prepare for your potential disability. Now, hopefully none of us will be disabled, but the chances are at least 25 to 30% in this room will be at some point. So you need these documents. The last one is optional. We're going to talk about all of these, but the durable power of attorney, a healthcare power of attorney, a living will, and a HIPAA waiver. I'm going to go through each one. So the durable power of attorney. A power of attorney is a document that allows you to name someone to act in your stead if you can't act for yourself, or if you don't want to in some cases. So in a durable power of attorney, we are appointing 1 or maybe 2 or however many people you want to make decisions for you if you can't make them for yourself. So you want to think about, well, who would make responsible decisions? Who thinks the way you would want them to think? Who's responsible enough to make sure things get done? And then always name at least 1 alternate. One thing I didn't put on the slide, but I need to bring up, is the word durable is very important. Before we had these durable powers of attorney created by our state legislatures, our regular old general powers of attorney would become invalid and ineffective the moment the principal, the person who set it up, became disabled or incompetent. So if I gave you my power of attorney, but I didn't have a sentence in it that made it durable, and I'm going to tell you what that is in a minute, and I wanted you to act for me, but then I became disabled, which is when I really need you to act for me. Guess what? My power of attorney was invalid. Didn't work. So these powers of attorney have to have a sentence that reads something like, this power of attorney shall remain effective in the event of my subsequent disability. You have to definitively state that this power of attorney will remain effective if you become disabled, incompetent, whatever. Very, very important. Quick war story about that. I'll help you remember, I think. When I was a brand new baby lawyer, I was practicing in Juneau, Alaska, and nobody can get there by car, by the way. You got to fly in or take the ferry in. So I had a new client come in, and it was a woman in her mid-80s, I think, and she had taken the ferry from Ketchikan up to Juneau, and she was a real estate investor. She and her husband was in his 90s, and he was in full-blown dementia and in the dementia ward at the local hospital in Ketchikan, which in 1991 was charging $12,000 a month for his care in 1991, 30-some years ago. So they had a large apartment complex in Ketchikan, or apartment building, that was under contract for sale. And does this still show? No. Under contract for sale. But it was in both of their names. And she set up the appointment with me because she said, I need a deed. I need you to draft the deed. This was in Alaska where the attorneys drafted the deeds. So I can sell this building. The closing is in a week. And I said, okay, tell me the situation, because I see this old deed as you and your husband. And so she told me he was incompetent, told me the whole story, and I looked at the power of attorney that she had. She said, I have his power of attorney to sign this deed. I said, great, let me look at it. Well, it was not a durable power of attorney. He was not competent. He didn't even recognize her. So guess what? That power of attorney was invalid. We couldn't use it to do the closing. We had to file a guardianship petition, which is a lawsuit, to get her named as his legal guardian. We had to give notice to his adult child, who was not her child, that they had been estranged from for almost 60 years, right? And she was petrified that this 50, 60-year-old, however she was going to destroy the whole proceeding. Anyway, the closing came and went and didn't happen, and it took us 2 years to get her guardianship. She didn't get the money. She lost that closing. All because that power of attorney was missing one sentence, because they had bought it at a stationery store and filled it out themselves. They didn't know what they didn't know. So it's terrible, isn't it? Terrible story. Anyway, so the durable power of attorney is really for everything but your health care. So all the decisions you make every day, paying your bills, hiring the landscape guy, whatever, all those decisions, that's your durable power of attorney. You also need one for your health care. Who makes your health care decisions if you can't do it yourself? Always name at least one agent, of course, but then always name contingents in case that first agent can't act. All right? And I would say, people used to say to me, well, I need to name someone in my same town. I'd say, no, you don't. You need to name someone who's going to make good decisions and be responsible. In this age of digital everything, physical location is not nearly as important as the person doing the job well. Okay, a living will. This is what we crudely call the pull the plug document. If you ended up in a situation where you have an irreversible terminal condition that would otherwise cause your death within a relatively short period of time, but you were being kept alive artificially on a ventilator, or sometimes even just by getting food and water by a tube, right? If you would not want to be kept alive artificially, you need this document. It's a totally optional document. But this document is it's the sword that your healthcare agent can use to force the hospital to terminate life support. Courts have said without it, it's really up to the hospital, not the family. Okay, very, very important. Remember the Terry Schiavo case? The family fought for years and went all the way up to the U.S. Supreme Court. This young woman, brain dead. Parents said, don't terminate life support. Husband said she never wanted this, terminate life support. Anyway, it was years and years and years. Well, she did not have a living will. That's why it went up to the Supreme Court. She'd had a living will, that it would have been terminated right away. So it cost many, many years and many, many tens and probably hundreds of thousands of dollars. All right, am I going the wrong way? I am. Okay, HIPAA waiver. You guys know when you sign away, you acknowledge you have privacy rights when you go to the doctor's office. We worry that your healthcare agent won't be able to get your medical information to make informed decisions because the doctors can say, no, that's private. So we usually do a HIPAA waiver for your healthcare agent to waive that privacy right for that person so they can get your medical information. And then this is totally optional, hospital authorization form, hospital visit, really, authorization form. Almost every state, I think, has a patient bill of rights where you get to say, if you're in a hospital, who can visit you and who cannot visit you. So if you're alive and competent, you can make that decision. Just sign the form or tell them. If you're not, it's nice to have this form already filled out. If you have non-family members you would want to be able to see you, or people you don't want to come in to see you, like estranged family members. So when I was engaged, but before I was married to my husband, I did a hospital visit authorization form to make sure that my fiance and his children could get in to see me, even though we were legal strangers. Just because we were engaged, we were still legal strangers. So I did the hospital visit authorization form for that. So if you have a special friend or a partner or stepchildren or somebody else that would not automatically be considered blood relatives, you might consider this form. Okay, we're going to talk about planning for death. So those are the big things you need for disability. And you can see why that's important, right? Everybody can see why those documents are important. And those should not be expensive to have an attorney help you prepare, a few $100 if that's all they're doing. So the money should not be something that holds you back. Look, another cute little cartoon. It's just so exciting. Okay. According to the latest study I could find, 67% of Americans have no estate plan at all. That's 2/3 of our country. That means it could translate to 2/3 of our room, average. Why do you think that is? Are there more cartoons? I love this. Does this play? Yeah, look, it's a fire. I even get like things going. This is so fun. Anyway, do people think they're immortal? I don't think anybody thinks they're immortal, but I think we all kind of act like we are when it comes to this stuff, right? We always think, well, I'll do that later. I'll do that later. I'll do that later. Well, my 62-year-old friend who dropped dead of a stroke doesn't have a later. Do we have a later? I hope so, but we don't know, right? Driving home in the rain last night, I wasn't so sure. Anyway, no, kidding. I'm kidding. Okay, I love this little cartoon. Do people think all attorneys are evil and that's why they don't want to do their estate plan? Do they think it just costs too much? Yeah, isn't that a cute little devil? Anyway, there are probably some nasty attorneys. There certainly are. There's nasty everything, right? There are good eggs and bad eggs in every industry, every profession. Does an estate plan cost money? Yes. Is it the best money you'll ever spend for your family? Yes, I think. Once you've fed them and clothed them, this should be the next thing. Not the cruise, not the new shoes. This should be the next thing you save for, in my opinion. Maybe an emergency fund, and then this. And then your IRA, right, Quincy? Anyway, I think nobody likes to pay lawyers. And I did, people complained about lawyers' fees. And I'm not practicing as a lawyer, although I do consult at $600 an hour, so I'm very expensive. But I was telling somebody this the other day. There are two things I heard when I was practicing as an attorney that I always wanted to say, and I never got to say them. One was if a client said, this is too expensive, to say, yes, professional fees are very expensive. If you'd prefer to hire an amateur, I'm sure you can get it cheaper. So think about that. It's very expensive to be a lawyer, by the way. The other thing someone said was, can you reduce your fee? Sure, what part of my services would you not like me to provide for you? Right? My fee is based on providing this package. If you don't like it, what should I cut out? So don't let the money stop you. Everybody deserves to be paid fairly. You want to be paid fairly. Don't let the fact that you think lawyers' fees are expensive stop you from doing this nicest gift for your loved one. Just save the money and do it. All right. Do people want their loved ones to be burdened with excessive income taxes, estate taxes, gift taxes? Of course not. Of course not. But we have to set the plan in place to make sure we're preparing for the tax planning that is available in an estate plan. If we have time, we'll talk about that in a minute. All right, don't they love their family? Of course they love their family. Of course, we all love our families. We love our church. We love our causes. What stops us? I know I'm beating the horse to death, but I really want you guys to not be one of the 67%. Right? Okay, make a plan. If you make that plan, these are some of the goals that plan can fulfill. So it can streamline your estate when something happens to you. We're on the death section now, remember? So it can streamline your estate administration or trust administration if that's what you have. We can use that plan to minimize the costs, the taxes, certainly the headache, make it a stress-free. And we can make sure that our beneficiaries get everything in the way we want them to get it. Is it outright? Is it in trust? Is it split equally? Is it unequal because one kid's in my business and one kid's not? That kind of thing. And we start considering, when you're thinking about this, the first thing we want people to consider is, well, what are your family goals? That's priority number one. How do you want this to benefit your family? Then we add on things like tax planning and ease of administration, and we look at what documents you're going to need based on your circumstances. And I would encourage you guys not to go to an estate planning mill where they spit out the same documents for every person, regardless of whether that's right for their situation. So think about that. Think about the information your loved ones will need to administer your estate. And we talked about this, documents and information. When we're thinking about what documents we need in our estate plan, we have to know first how assets pass at death. This, by the way, is the number one thing that people don't know when I met with them. We've all heard about a will. Most people think everything goes through their will. That is simply not true. And in fact, for most of our complicated lives, that's only a small piece of it that actually goes through our will. All right, we're going to talk at length about that. But we need to know how things pass at death, because we need to know, does that asset pass directly to someone else? Does it pass through my will? Does it pass through a trust? How does it get to the people I want to inherit? And like I just said, the asset, how it will pass depends on how it's titled at the time you die. So this is my little chart. We're going to go through it because this is really important. You guys should all take a picture of this. If you can see it, take a picture. I'm going to step aside for a minute. Step further. Yeah, everybody take a picture. So, if you do nothing else, you learn this slide. Learn this slide. The only thing that goes through your will, if you have one, are things titled in your separate name at the time of your death. The deed reads Mary Hart. The bank account reads Mary Hart. There's no beneficiary. There's no joint owner with the right of survivorship. It's not in a trust. If it's just in my name, it's going to pass through my will when I die. Or if I don't have a will, then my state legislature has created one for me. And it will pass through my legislative will, where the state thinks I want it to go, which may not be anything like the way I want it to go. The people I want to get it, the way in which I want them to get it. But if something is in my separate name, I know that it's going to be governed by my will unless I do something else. All right? So it's in your separate name. It passes by last will and testament to my devosees. That's a legal term for those people you've listed in your will as the beneficiaries. If something is held jointly with a right of survivorship, WROS, with right of survivorship, it is going to pass by, how did I get that? It's going to pass by operation of law to the joint owner the moment I take my last breath. If Wendy and I have a piece of property and it says Mary Hart and Wendy Sweet as joint tenants with the right of survivorship, then the moment I take my last breath, I'm assuming I die before her, she'll own it. If she takes her last breath before me, I'll own it. So let's say I died first, and in my will, I left my half of that property to my husband. He's not going to get it. It's not in my separate name. Wendy and I own it as joint with the right of survivorship. If I didn't understand that, my estate plan would not be effectuated, right? So joint with the right of survivorship will pass by operation of law to the joint owner. Now, just because you have two names on a titling document does not automatically mean there's a right of survivorship. It could be joint without a right of survivorship, which we know as tenants in common. You guys hear that term, tenants in common, right? Tenants in common, if Wendy and I owned that property and the deed read Wendy and Mary as tenants in common, it would be as if we each had our separate share. Let's say it's 50-50. It doesn't have to be. It could read 40-60, 70-30, whatever it is. But in my example, my 50% would be considered in my separate name and go to my beneficiaries through my will. Wendy's would go to hers through her will. The only difference is there's no right of survivorship. But people just see two names and they automatically assume it goes to the survivor. You have to know whether it has a right of survivorship or not. If something is titled in the name of a trust, it's going to pass outside of your will per the terms of your trust. It will go to the trust beneficiaries. So whether that's a land trust, a personal property trust, a revocable living trust for estate planning, an irrevocable trust, it doesn't matter. If the name on the title, whether it's a bank account or real estate or anything else, reads the trust or the trustee of that trust, it's going to pass through the trust, not through your will. If you have what's called a pay on death account where you have named beneficiaries, that could be your IRA, that could be your life insurance, that could be a bank account, a stock account. If you've named beneficiaries, that's a contract that says that when you die, those assets go to those named beneficiaries. So even if you say something different in your will, it's not going to go through your will. It's going to go to those named beneficiaries. Let me tell you another war story. Some of you have heard me talk about estate planning. I've heard this one. Again, I was a young attorney in Alaska, and the state of Alaska had a really amazing retirement benefit program for its employees. And there was a woman who died very tragically at age 42 in a scuba diving accident. She had 2 sons who were like 19 and 20. She had a life partner. They were not married. When she first got with that life partner, she had done her retirement plan beneficiary 75% to her sons, 25% to her partner. Fast forward 10 years, 15 years, whatever it was, she changed her will and said, I leave my state of Alaska retirement benefits 50% to my partner, 50% to my children. She never changed the beneficiary form, which is what governed the retirement benefits. The will didn't govern it. It had a beneficiary form. By contract, it had to pass to the beneficiaries on that form. So she died, and the partner assumed he was getting 50%. Nope. Kids got 75%. Well, there was a lawsuit. I ended up representing the kids. We ended up settling for somewhere in between the 25 and 50% that would go to the partner. But that was just because the kids decided to. They legally didn't have to give him a dime. All right? Because the mom did not, she tried to do her estate plan right. She was on it, which was surprising for a 42-year-old. But and it was large. It was close to $1 million account. She did not realize that her will didn't govern it. The beneficiary form did. Everybody thinks, well, it's in my will. I don't care. It doesn't govern that asset. So pay attention to that. My little computer does not like to stay on unless I'm active. Okay, so I want you guys to think about your homework. I know this is not school, but I am going to give you a little homework request because I think it's beneficial. You should take a spreadsheet, and in the left-hand column, you should write down every asset you have an ownership interest in, whether it's 1%, 10%, or 100%. Then you should go look at the titling document and figure out exactly how it's titled and write that in the next column. Then in your third column, you should take that chart you all took a picture of and figure out what document governs the passage of that asset when you die. How does it pass at your death? Because you might be surprised. Can't tell you how many times people would come to me when somebody died and said, well, Mom and I had a joint account with a right of survivorship. I'd say, well, we have to get the signature card from the bank. It wasn't a right of survivorship. So the daughter didn't get that account, for the whole account. They all operated under the assumption it was with a right of survivorship, but when the well-meaning bank employee set it up, they never asked the question and they checked without a right of survivorship. Know your titling documents, okay? Jim, don't let me go over. I don't know quite how much time I have. I don't know if he's in the room. All right. So the documents that we see the most often are a last will and testament for those things in your separate name, revocable living trust for things you want a title in it. This will avoid probate, and if we had a longer time, we'd talk more about that. Beneficiary forms, irrevocable trust. These are some of the main documents that we use in an estate plan, and which documents are right for you will depend on your circumstances. That's why you have to know how your assets are titled, to know which documents will work and which ones you might want. Your will, again, only for those things in your separate name, it's going to determine the distribution of those assets, only the ones held in your separate name. It is governed by your state law. It can be handwritten in some states, but I would not recommend it. And frankly, I'll probably get in trouble by LegalZoom and those type of people. I would never use an online program. In my 33 years of doing this, every single will contest I ever saw was someone who handwrote their will or used a LegalZoom type program. Every single one. Why? Because you don't know what you don't know unless you've gone to law school about it. And it's either vague, which makes it unenforceable, or you've got conflicting provisions, which makes it unenforceable, or you forgot something, which makes it unenforceable. Not unenforceable, but unenforceable as to that asset if it's not talked about. All right, so it is subject to probate. Whatever goes through your will or whatever goes through your legislative will, so things in your separate name do go through probate. That is the process where the court administers your estate with the executor, or the personal representative is what we call it now. That process can be tedious in some states, okay in others. It's never fun. It's never fun. So I personally have chosen to avoid probate by owning everything either in a revocable living trust, because what did that do? I had a house deeded to Mary Hart. Now it's deeded to Mary Hart as trustee of my revocable trust. It's not in my separate name anymore. It's in my name as the trustee. Now it's going to go through my trust. See what I did? I just stopped probate for that asset by changing the title. So if I had a bank account in my name, now it's in my name as trustee of the trust. So now my assets either are going to pass automatically, like certain of my retirement accounts I'm giving out automatically to my spouse and my children. My properties are either in LLCs, which are now owned by my revocable living trust. So I'm funneling everything up to my revocable living trust so that it doesn't go through probate. And by the way, if you have real property in multiple states that are in a person's name, not in an LLC, not in a trust, that real property is going to have to go through probate in the state in which it's located. So like I have properties in Virginia, North Carolina, Kentucky. All of mine are either in an LLC or my revocable trust. My LLC is in my revocable trust. Why? I don't want my estate to go through probate in North Carolina, Virginia, and Kentucky. That'd be terrible. So I put them in LLCs. That makes them personal property. My trust becomes the owner of my LLC, which makes it avoid probate. So I've got a house that's in an LLC, that's in a trust, and I'm the owner of that trust. See what I mean? So when I die, everybody just looks at the terms of my trust and administers it that way. Okay. Uh-oh. Clicker's not working. Who's? Oh, I got a box. No, box. Ah, did it work? There we go. Not a techie. Okay. So those pay-on-death beneficiary designations we talked about, that could be your retirement plans, your life insurance. There are certain bank accounts and stock accounts that allow you to name a beneficiary directly. That's a pay-on-death beneficiary designation. That does not go through probate. Even though it's in your separate name, it's got that beneficiary designation contract that takes it out of probate and gives it directly to your beneficiaries. Okay? It's a private document. It's not filed anywhere other than the custodian who's holding the asset. You create it by signing a form, and you can change your beneficiaries as long as you're alive and competent. Irrevocable trust, we're not really going to talk about. We don't have time in the scope of this presentation, but that is a form of trust that we use for various purposes. Often it is for creditor protection or to get assets out of an estate for estate tax purposes or whatever. Like your revocable trust, it is a private document. It's not filed anywhere. This one, however, cannot be changed. Once you set it up, it's irrevocable, unchangeable, unless you go to a court proceeding to change it, which is difficult and sometimes not possible. When you use an irrevocable trust, the one thing I really want to point out, a lot of people say, well, I'm going to set up an irrevocable trust and throw all my stuff in it for my kids so that it's not subject to estate taxes when I die, or whatever the reason is. People don't realize when they do that, when you transfer an asset to someone or to a trust during lifetime, you are transferring them your tax basis in the property. Now, the normal rules, let's use me. So if I had a piece of property, let's say I bought it for $100,000 and now it's worth $500,000. If I sold it for $500,000, assuming it's not my residence, I have $400,000 worth of capital gains, right? Bought it for $100,000, tax basis. This is a very simplified example. Bought it for $100,000, sold it for $500,000. I'm going to pay taxes on $400,000 worth of gain. If I die with that house in my name, or even in my revocable trust, and it passes to my kids at death, it's going to get a step up in basis, tax basis, to what it's worth on the day I die. So the tax basis will jump up to $500,000 if that's what it's worth. So if my kids sell it the next day, no capital gains taxes. If I took that same property and I transferred it either to my kids or to an irrevocable trust for their benefit, my basis, the $100,000, carries over to them. They don't get that step up because it wasn't included in my estate when I die. So when you guys make these decisions, please talk to a professional because you're weighing Okay, escaping estate taxes, going to be capital gains taxes. Maybe I don't have a taxable estate. Maybe the income taxes are more important. This is why it's important to talk to someone before you make these decisions, because so many people have done what they thought was a well-meaning, wonderful thing for their family, only to find out, the family finds out because the other person's deceased, that they actually messed their family up and cost them a lot of money. So an irrevocable trust does not get that step-up in basis when you transfer that asset. So joint ownership with the right of survivorship, this isn't an estate planning document per se, it's the titling document that says that when you purchase something or open an account or whatever it is you're doing, that you have a joint owner with the right of survivorship. So in my example with Wendy and I owning a piece of property, joint with the right of survivorship, it's just the deed. It's not a separate estate planning document, but that deed dictates that it goes to Wendy on my death. And by the way, once you put a joint owner on a property, you can't remove them without their consent. I had a stepsister who had a partner. She inherited some money. She went out and bought a property, a very expensive property in Wyoming, and she put her boyfriend's name on it. They weren't even necessarily a committed relationship, but she wanted to do something nice. Well, what do you think happened? A year later, they break up. She calls me up. I never hear from her. She calls me up. Hey, how do I get my house back? Like, what? You don't. Not unless he agrees. She, well, it was my money. It was my house. I was just being nice and put him on the deed. Well, that was stupid. I mean, I literally had to say that. Why? That was really stupid. I said it in a loving way, of course. But I said, at this point, how is your relationship? She said, well, it's kind of iffy. When he broke up, it wasn't really great. I said, you better start kissing up. Make up with him. Get him to sign you the deed, and then you can break up again. Anyway, long story short, he did the right thing. He signed it back over to her. But guess what? When she made that gift to him, let's say it was $500,000 property, paid for in cash, she made a $250,000 gift to him. She could only at that time have given him $16,000 without filing a gift tax return. She wouldn't have owed gift taxes because she has a bigger credit. But she did that. And guess what? When he deeded it back to her, he made a gift to her of $250,000. Should have filed a gift tax return. So these things get complicated. You need a professional. We've talked about this one, the tenants in common, so I'm not going to go over that again. Life estate. How many of you guys have heard of the life estate? Yeah, a lot of people have heard of that. So let's say that I had a piece of property and I wanted Wendy to have it when I'm gone. I don't want to set up a trust. It's too complicated. I don't want to transfer it right now, blah, blah, blah. I could create a deed where I reserve a life estate, which gives me the right to that property while I'm alive, but the terms of the deed say as soon as I die, she owns the remainder interest, which the moment I die is everything. So it's split into like two interests, a lifetime interest and the remainder interest. While I'm alive, we each have something. I have the life interest, she has the remainder interest. When I die, that life interest is extinguished. There is no life anymore. And now she owns 100% of it. So you can do that. We see that a lot in Medicaid planning and between family members. So that is a way to do that. But just realize that the life estate holder, like if I reserve the life estate for myself and I've made Wendy the remainder man, I can no longer go sell that property without her consent. She has a vested interest in inheriting that property now. So don't do these things willy-nilly. By the way, before you say, I'm going to give all my assets to my children so I can qualify for Medicaid one day, go talk to a professional. You may have just screwed your children over that way. If you say, I'm going to make one of my 3 children the joint owner on my account so they can sign checks when I'm in Europe, don't do it. Because you probably just inadvertently made them the joint owner, not just an authorized signer. So your will says my bank account goes to all 3 children, but guess what? You die, it goes to that one child who doesn't have to share it with her siblings. So talk to somebody before you make these decisions. Okay. How are we doing on time? We only got about 7 minutes. We're getting near the end. 15? Okay. So I want to talk to you briefly about this. This is very important. We have been in an era of increasing estate tax exemptions, meaning how much you can leave to your beneficiaries free of estate taxes. That is coming to a rapid halt in 2026. Right now, well, let me back up. So the top gift and estate tax rate is 40%, you guys. This is a high tax bracket. It used to be 50%, in some cases 55%. It's 40% right now. The good news is there are some exclusions, credits, and deductions that mean you don't always pay that gift or estate tax, right? I can leave an unlimited amount to my U.S. citizen spouse. So if I were Bill Gates and I had billions of dollars and I wanted to leave it to my spouse, no estate tax when I die. My spouse could inherit it free of estate tax. I could leave an unlimited amount to a charity and not pay estate taxes on that. In addition to that, if I want to make annual gifts, I can give as many people as I want, $18,000 a year, without having to file gift tax returns. That's per calendar year. So if I had 10 children and I was trying to whittle down my estate, I could write checks for $180,000 a year, $18,000 each one of them, and just start shuttling money out of my estate. I also have what's called a unified credit against gift and estate taxes. Right now, that says that either during my lifetime, at death, or some combination thereof, I can leave $13.61 million free of gift and estate taxes. So Ven's looking interested over there. So if I said, Ven, how'd you like $5 million? I could give him $5 million. Winnie, I'm going to give you $5 million. Robert, I'm going to give you the rest. Totally free of gift and estate taxes. Have at it, right? No problem. If I die with $13.61 million, let's say I never gave any of it away because I'm cheap and I want it all, but I die with it, I can't take it with me to heaven. So I've got $13.61 million and I leave it all to Wendy. There you go, Wendy, that's a big gift for you. No estate taxes right now and in 2025. But in 2026, that amount that is sheltered, that 13.61, drops to $5 million indexed for inflation since I think 2011. So now they're saying that's probably around 7 when you add the inflation. That's a big difference. 13.61 down to 6 or 7. When we're real estate investors, and Jim made mention of the amount of net worth in this room, think about the net worth in all your properties, your personal home, your stocks, your gold, your everything. Total it up. Do that. Add that to your homework list, the fair market value. And let me talk a minute about that. What the IRS cares about when they're valuing your estate to see if you owe estate taxes, they want to know every single thing you have an ownership interest in, whether it's 1%, 1/4%, or 100%, doesn't matter. They want the fair market value, what a willing buyer would pay a willing seller, everybody having full information and nobody being under any compulsion to buy or sell. That's the definition of fair market value. They want the fair market value of that asset. When I did an estate tax return in Alaska when I was a baby attorney, it was an estate for a native Alaskan who had a huge, gorgeous collection of native basketry and ivory carvings and all this stuff. They wanted to just pass it down to their children, been in their family for generations, or however long time. Well, the IRS made us value that on the estate tax return at what a retail gallery would sell it for. It was never going to be sold. It's personal property, been sitting in their living room for, however many decades. But we had to put it down and get an appraisal done and send pictures into the IRS and everything else, because the IRS wants you to add up everything. And during that estate tax return, I was reading the practitioner's manual for the IRS people who are auditing estates. And there was a tip. They would have all these practitioners' tip. And one of them was, ask the ambulance driver how much cash the dead guy had in his pockets when they picked him up. I read that, I about fell out of my chair. But literally, that was what the IRS, the tip they were giving to their auditors. Find out if there was cash in the deceased, they didn't say the dead guy, in the decedent's, personal effects when they got in the ambulance. That's the IRS, people, don't mess around. Oh, come on. I'm gonna have to, there we go. Okay, so we wanna pay attention to this because what do we do if your estate is going to be higher than 5 to 7 million when you die in 2026? So there are a couple of things. One, I didn't even write on here. Each person has this amount, this credit. So if you're a married couple who own all your assets together, that credit amount is doubled if the estate plan is set up properly, or if a box is checked on an estate tax return. We don't have time to go into it right now, but I just want you guys to realize it can be the husband and the wife. If you're a married couple, just make sure your plan is set up. Talk to a professional. But either, if you're over that, we either need to first make sure both spouses take advantage of that credit, make sure your plan is set up properly, or we need to reduce the number of assets, start giving it away to your loved ones, your charities, your kids, whatever it is, or reduce the value of those assets, which we can sometimes do through using family limited partnerships or limited liability companies where, you know, what was worth $100 outside of the LLC is now worth $70 in it. And I don't have time to go into that, but there are ways that works. Or we want to say, well, we can't get rid of any more assets or reduce the value, but we're going to have a massive estate tax bill. You can always use life insurance, own it in a separate irrevocable trust, so it is not subject to estate taxes itself, and it's not subject to income taxes, and you could use that to pay your estate taxes with cheaper money. So maybe I buy a $2 million policy, and maybe I even pay $1 million in premiums over my lifetime. But if I had a $2 million tax bill, and that life insurance paid it, I'm basically paying a $2 million bill with $1 million. It cost me $1 million to pay a $2 million bill. See what I mean? So life insurance can be very useful for that situation. All right, this is important. Lawyers are going to be busy, very, very busy. If you're going to be in that situation where your net worth is $5 million or more, $7 million or more in 2026, start calling your lawyers now and get in and start making a plan. Because all this will take a lawyer. This is not a DIY plan. Okay, we only have a few minutes, 1 minute. So what I want to tell you is the information. What do your families need to know? What's the second half of your letter, your love letter? This is have I scared you yet? Because I was going to ask you a bunch of questions that we don't have time for. But all those things I said to think about, does your family know how to pay the bills? What's on auto pay? Who you own things with? You got notes out there? Who owes you money? All this stuff. Do your loved ones know that? And this list was really going to scare you, but I don't have time for it. So are you scared yet? Just imagine that I scared you. Imagine. Okay, this is what I've done. This is my literal notebook that I'm working on right now. It's called My Ultimate Love Letter, and I have down the bottom my name and every date it's going to be revised. And what I'm putting in it is everything you can think of. All my personal information. My name, my birth date, my social security number, my address, every other address I've ever lived in the last 5 years, whatever it is. My family, who's my spouse, who are my kids, what's their information? Who are my advisors? Who's my insurance agent, my attorney, my CPA, my property manager, anybody I can think of. All of my assets. And I have a complicated estate, so for each asset, I'm going to do the whole list, and then each asset will have a detail sheet. See details on Schedule 1 or whatever it is. So for real property, I'm going to put in my detail list, the address of the property, when I purchased it. Oh, and here's a copy of the HUD statement that's in there, so if anybody needs to know the basis, right? I'm going to put in what bills are paid on a recurring basis, what account are they paid out of, is it auto pay, is it not auto pay, when do I have to pay the property taxes, where do I send them, who's the HVAC guy, who's the plumbing person, anything you can think of, right? My LLCs. Do I own it 100%? Am I a partner with someone else? What's their information? How do we find those people? What's the operating agreement that says what happens if I die? Go find it. You know, I want all that. I want copies of deeds, insurance policies, operating agreements, bylaws. Any asset I have, I want it in a giant notebook. Now, I'm personally going to do paper and digital. But you don't have to do the paper. You can just do digital and put it on a thumb drive, stick in your safety deposit box or your safe or whatever. Let your family know you have it. All this stuff, my driver's license, my passport, my global entry card, if I had a military record, all that would be in there. So they would have one resource. Oh, we need to know what subscriptions mom had that we need to cancel. What's she a member on? What's her credit cards? What's her passwords? How do we get in her password app? Right? How do we get in Facebook? How do we shut that down? What's my religious affiliation? Who do I want to do my service? Do I want to be cremated? Do I want to be buried? Do I have a burial plot? Where is it? What's my family history? You know, if my kids want to know 5 generations before me, do I even know that? I would love to know that. Copies of everything. If you're doing this as a digital document, you want a password protected, of course. All right. You can see where I'm going with that. Our death is inevitable. Let's make it easier. In this picture, when I see this picture, and it's a morbid picture, and I apologize for that, but we're talking about morbid stuff here that's important. I look at that picture, and I see 2 families in my mind. Both families are looking at this casket of their loved ones, and they're grieving terribly. They're very, very sad. But one family is still secure knowing that, okay, everything's set in motion. I just got to meet with the lawyer next week and it's smooth sailing. The other family is not only grieving, but they're fractured. They're, oh my God, I don't even know what to do. What do we do next? I don't know where anything is. I don't even know what credit cards they had. I don't even know where anything is. And they're freaking out. So they can't just grieve their loved ones. They can't go about that process of healing because they're fractured by all this unknown and this, oh my gosh, I don't know what to do. I don't even know who to call. We've got guests checking into that Airbnb. I don't even know what to do. Make it easier on your loved ones. Have I scared you all yet? Have I inspired you or encouraged you to think about this? I know it's no fun. I know it's no fun. Just please do me that favor. Now, next comes the shameless promotions, and then I'm done. Here's the shameless promotion for the Sweetheart Women in Real Estate Mastermind. And it did come up last year. It started last year when Allie Crook offered her tiny homes up for auction to support Share the Love. Wendy and I were helping with the auction, and Wendy comes up to me and says, we should do this as a mastermind. I'm like, sounds great. And we had so many people sign up, we had to move not only her tiny homes, we had to then book an entire lodge. We had 26 of us for 2.5 days, and it was really kind of a life-changing thing for me, and I've heard from several other people that was life-changing for them. We opened it back up for the second one, which is coming up this October, starting in September. And the first mastermind sold out. We opened it up 30 spots, and we had 36 people, including the two of us. So 34 people going in 2.5 days. I'm like, oh my God. I mean, paid the deposits and everything. I'm like, we had 15 more people saying, how do I get in on this? So now there's a second one. October 2nd to the 5th, that QR code will take you to the website that'll tell you how to get in touch with us and how to sign up if you're interested. We have women it's all women, sorry guys. Michael Hicks tried to impersonate a woman last year and showed up as Michelle. There are pictures, they're scary, but he did come to the first dinner, but then we had to kick him out. Because there's one vital piece of equipment you do not have. Just saying. Other than that one vital piece of equipment, anatomy, that all of us share in the mastermind, Wendy wants me to say a word, and I'm not going to say it. She's going to have to say it. Because I'm on camera. This is being filmed. But in any event, we are a group of, daughters, mothers, grandmothers, aunts, sisters. Some of us have children. Some of us have no children. Some of us have grandchildren. Some of us are young, some of us are older, some of us are rich, some of us are poor. It's everything. Everything a woman can be is in that group. And no offense to any of the guys, we love all the men. And it is not, by the way, a male bashing event. It is not a feminist burn your bra event. It's none of that. It is a very safe space, a nurturing space for each woman to get up in their own little 30-minute time slot. Most people call that the hot seat. We call it the Hart suite. You're on the Hart suite, and you stand up in front of the crowd, and you tell people what you're doing, what's working, what's not working. And you have 25 board of director members that help you and encourage you. And it really has changed lives. And it's not because of Wendy and me, it's the power of the group. So if you're a woman in this room, and you're interested in coming, get that, did I back it up? Get that QR code, and that will tell you how to get in touch with us, and it goes to our website, sweetheartmastermind.com, if you don't want the QR code. Yes, Allie. Yeah. Well, and I think, the most powerful thing to me is that the level of experiences in that room is sort of astronomical. If you think about 30 of the women in this room, I've been in real estate investing since 2004. I've been an attorney for 33 years. Wendy's been in it forever. The people in the room had so much experience, and so there were a lot of people that just said, wow, and it did change people's businesses and people's lives. And it wasn't even just all business. Some people talked about their personal life and have reported that things are better. It really was a great thing. So what started out as a charity fundraiser for Share the Love is now hopefully an ongoing thing. We do still plan to give a big percentage to Share the Love, so that's going to happen from the proceeds of this. All right. The next shameless promotion, on that Ultimate Love Letter notebook, because I've been encouraged by other people, my templates will be available for sale at some point. I've spent a lot of time on it, and I'm not done. Somebody's got to go make it pretty. and digitize it and all that. So I have no idea what I'm going to charge, what it's going to be, whether we're going to offer services to help people do it or not. But if you just want an email to know that that template is available out there, scan that QR code that says scan me, and I'll put you on an email list, and you'll get that notification. The other QR code, Allie Murphy set up for me, and it is a what do you call it, Popple account. It's a way you can connect with me. It has links to my AIM membership website, to my YouTube channel, to my Facebook channel, blah, blah, blah. And I think you can put in your email, and you can get my email and my phone number.